The deportation of Kilmar Abrego Garcia is unfolding now as one of the most polarizing moments in America's current immigration discourse. Not because the facts are clear, but because the facts are interpreted through sharply different lenses. To some, Garcia is a dangerous man who should have been removed long ago. To others, he is a legal resident whose rights were violated. Some see a failed system, others see a successful policy. The same facts are being used to draw opposite conclusions. At the Polytely report, the goal is not to resolve the debate. The goal is to understand what the debate is really about, what values are driving the conversation, what fears people are responding to, what assumptions we are making. This is how we can identify areas where we cannot agree. This is also where we can begin to find shared values, even when we disagree on how to put them into practice. Kilmar Abrego Garcia, a Salvadoran man who had been living in Maryland for over a decade, was deported in March 2025, despite a standing U.S. immigration court order that prohibited his removal. That order cited credible fears that Garcia would face persecution if returned to El Salvador. Though he has no criminal convictions, federal officials point to a mix of past allegations, some involving gang affiliation, others domestic abuse, to justify their decision. The administration admits the deportation may have violated court procedure, but defends it on national security grounds. His case now sits at the center of a broader clash, about law and power, about fear and fairness, about what it means to belong. We evaluated 6 articles from across the political spectrum for this analysis. Instead of analyzing each article in isolation, we trace core themes that recur across coverage. Each represents a distinct cultural logic, and each is rooted in a different understanding of what's at stake. The dominant concern across coverage is security. Nearly every article treats public safety as a central question, not just for rhetorical effect, but as the backdrop against which every other claim is evaluated. The Daily Wire places it at the forefront, framing critics of the deportation as willfully ignoring the threat posed by undocumented immigrants. The piece argues that procedural concerns are being weaponized to obscure a basic duty, keeping Americans safe. In that view, security isn't just a policy objective, it's a moral responsibility. But even in more critical coverage, security is a centerpiece concern. The New York Times emphasizes the idea that due process itself is a safeguard, that legal adherence protects not only the accused, but the integrity of the system and the safety of all. Here, the failure to follow procedure is framed not just as a technical error, but as a breach that risks broader harm. So while the conclusions differ, the premise is shared. Protection matters, and any policy's legitimacy rests, at least in part, on whether it keeps people safe. From here, the conversation branches into fundamentally different perspectives. These splits don't negate the shared importance on safety, but grow from it in different directions. For supporters of the deportation, justice is framed as preventive. The idea that acting early, based on suspicion or risk factors, is a responsible form of protection. The Daily Wire reflects this reasoning, dismissing legal objections as technicalities that distract from real dangers. Politico shows how this logic is amplified through emotionally charged stories of unrelated crimes, illustrating the belief that some hold that preventive action, even if aggressive, is morally necessary. By contrast, critics frame justice as procedural. For them, legitimacy comes from following the law, not from acting on instinct. The New York Times and The Atlantic emphasize that Garcia's deportation violated a court order, and that the administration changed its justification only after facing legal backlash. In this view, justice is measured by how decisions are made, not just by what outcomes they produce. Another split emerges over what counts as credible grounds for action. Some government officials and sympathetic media treat patterns of association, gang-affiliated clothing, a past restraining order, transportation of migrants, as sufficient cause for alarm. The BBC and Politico both report that much of the alleged evidence is vague, dated, or uncorroborated, yet still cited in defense of the deportation. Critics argue that these patterns fail to meet the threshold of evidence. Federal judges found no credible proof connecting Garcia to criminal activity. They emphasize the legal standard that allegations require verification, not just a consistent narrative. This divide is not just about data. It's about how people decide what to trust, whether we should act on plausible patterns or wait for proof that can stand up in court. And where is the handoff? When does enough credibility count so that evidence isn't necessary? What's happening in this debate is not chaos. It's the collision of moral systems, each internally coherent but not always compatible. So let's look at where reconciliation is unlikely to occur, and then where there are opportunities for it. The first and most significant fracture in this debate is how justice is defined, as preventing harm or as following the rules. Supporters frame Garcia's removal as a precaution. The Daily Wire argues that waiting for perfect legal clarity in cases involving alleged gang ties could expose the public to preventable danger. From this view, inaction is not neutrality, it's risk. The role of the state is to anticipate harm, not merely to respond once it's too late. By contrast, critics argue that justice must be procedural. The New York Times and The Atlantic highlight that Garcia's deportation violated a standing court order, a direct breach of the legal framework meant to protect individual rights. In this frame, obedience to process is the very mechanism by which justice is secured. Acting outside of it, even for noble reasons, weakens the rule of law. These aren't just different tactics, they are incompatible definitions of justice. One side sees delay as failure, the other sees haste as abuse, and each views the other stance not merely as mistaken, but as reckless. Closely related is the question of what counts as a valid basis for action. Supporters of Garcia's deportation point to indirect indicators, prior allegations, associations, and symbols of gang affiliation. Politico details how the administration emphasized these signals, even in the absence of convictions, as part of a broader threat pattern. The BBC reports that some of this information came from informants or unverified sources, yet was treated as meaningful. Critics argue that these patterns are too tenuous. Federal judges reviewing the case found the evidence against Garcia insufficient to meet legal standards. For them, allegations must be corroborated and tested, not simply repeated. They warn that pattern-based logic can easily drift into profiling, where suspicion becomes self-justifying. This isn't just a debate about credibility, it's a debate about how knowledge is constructed, whether it's more dangerous to act on imperfect information or to wait for proof that may arrive too late. Finally, there is a deeper fracture over the role of narrative itself. The administration's messaging shifted significantly over time. The Atlantic documents how Garcia was initially framed as a routine deportee, until legal pressure mounted, at which point officials began describing him as a national security threat. Politico shows how the administration invoked unrelated crimes committed by other migrants to bolster its case. Supporters might view this as strategic communication, a necessary recalibration to manage public reaction and political cost. Critics, however, see it as opportunism. The story shifted not because the facts changed, but because the public needed a different story. Here, even agreement on facts can't bridge the divide, because the method of persuasion itself becomes suspect. When narrative framing is viewed as manipulation, trust collapses, not just in this case, but in the broader ability to reason together. Now let's look at areas where reconciliation may be possible. Both sides distrust the system, just for different reasons. One side sees the courts as slow and unresponsive to real-world threats. From this view, justice delayed is justice denied, not for the accused, but for the public. When legal processes stall, preventable harm can occur. Institutions that are too cautious become complicit in danger. The other side sees the executive branch as too willing to override legal constraints. Here, too, justice delayed is justice denied, but in this case for people like Garcia. When the state violates due process, it inflicts punishment without accountability. Every day spent in unlawful detention becomes its own injustice. Each is arguing that the cost of inaction is harm, just targeted in different directions. Each side sees the failure to act properly and promptly as a threat to justice and safety. The shared fear is institutional breakdown, not just inefficiency, but a betrayal of duty. And that shared fear could be a foundation for reform, not to resolve disagreement, but to build better guardrails around power and responsibility. Everyone in this conversation is trying to protect someone. Some are trying to protect the public. Others are trying to protect the principle of justice. If each side can recognize that the other's position comes from a moral commitment, not malice or naivete, then mutual respect becomes possible, even amid deep disagreement. Some critics, including Senator Chris Van Hollen, suggest they might support deportation, but only if it followed lawful procedures. That opens a narrow but real path toward consensus, not on whether Garcia should be deported, but on what standards must be met first. But that path is fragile. In a political climate this charged, even gestures toward compromise are often seen as concessions. A single procedural defense may be interpreted as indifference to human rights. A single legal critique may be treated as hostility to enforcement. The middle ground exists, but is it acceptable to either side? There are opportunities to recognize the legitimacy in both perspectives, and how each seeks to protect the innocent and uphold justice. The harder question is whether there is an appetite to acknowledge that legitimacy. In this climate, people often ask, if I admit there's some truth in your view, does that make mine weaker? Will I be branded as disloyal? To build a more honest and productive conversation, certain recognitions would need to occur. Security-first advocates need to accept that violating court orders, even for seemingly good reasons, undermines the legal protections that guard all citizens. Due process defenders need to accept that public fears about crime are not inherently irrational. Behind those fears are people who have experienced real harm or worry they could be next. Legalism must respond not only to principle, but to the lived experience of those who feel unprotected by the system as it stands. It isn't just a matter of respecting the other side's position. It's recognizing that the other side's concern is a necessary part of justice itself. Protection without procedure becomes unchecked power. Procedure without responsiveness becomes brittle and blind. Finally, both sides would need to stop treating disagreement as evidence of bad faith. Each side is trying to prevent harm. The question is what kind of harm they fear most, and that may require understanding what kind of harm is most present in those people's lives. This is not a call for consensus. It's a call for clarity about what can be negotiated and what cannot. You've been looking at this man for almost the entire video. His name is Kilmar Abrego Garcia. While we've talked about courts and policies, security and fairness, trust and fear, he hasn't changed. He is not an abstract concept. He is a person. Whether he's innocent or guilty, his life is a real life. And when we turn people into examples, into cases, into commentary, into symbols, into scapegoats, we risk forgetting what's underneath it all. A person. We owe him and ourselves the dignity of remembering that. The case of Kilmar Abrego Garcia is not just about immigration policy. It is a mirror reflecting deeper fractures in how we define safety, fairness, and truth. Both sides are appealing to justice as protection, but they differ on who needs that protection most immediately and what kind of delay constitutes failure. What this conversation lacks is not passion or principle. It lacks shared definitions and, more importantly, shared recognition, the ability to see the moral value of the opposing side, even when rejecting their conclusions. Thank you for spending this time with us today. We hope that you will join us again soon when we will look at another pressing issue of our time, the many perspectives and goals that surround it, and go deep into them to see what is truly between the lines.